Why read the Florida condo law updates from the 2024 legislative session if you can watch and/or listen to it? This is part one of a four-part audio and video narration of the 2024 Florida condo law revisions. This video and audio was created by Miami consultant Peter Zaleski of condovultures.com by copying and pasting the verbiage directly from the Florida legislature website. The audio is an AI-generated voice. To obtain a copy of the changes to the Florida condo law used for this video and/or audio, please visit https://laws.flrules.org/2024/244. Chapter 2024-244. Florida House Bill No. 1021. Except as otherwise expressly provided in this act shall take effect July 1, 2024. Approved by the Governor June 14, 2024. Filed in Office Secretary of State June 14, 2024. An act relating to community associations, amending S. 468.4334 FS. Requiring community association managers and community association management firms to return official records of an association within a specified time after termination of a contract, requiring notices of termination of certain contractual agreements to be sent in a specified manner, authorizing community association managers and community association management firms to retain, for a specified timeframe, records necessary to complete an ending financial statement or report, relieving community association managers and community association management firms from certain responsibilities and liability under certain circumstances, providing a rebuttable presumption regarding noncompliance, providing penalties for the failure to timely return official records, providing an exception for certain time periods for timeshare plans, creating S. 468.4335 FS, requiring community association managers and community association management firms to disclose certain conflicts of interest to the association's board, providing a rebuttable presumption as to the existence of a conflict, requiring an association to solicit multiple bids for goods or services under certain circumstances, providing requirements for an association to approve any activity in contracts that are a conflict of interest, providing that a conflict of interest in a contract which has been previously disclosed must to be noticed and voted on upon its renewal, but not during the term of the contract, authorizing certain contracts to be canceled, subject to certain requirements, specifying liability and non-liability of the association upon cancellation of such a contract, authorizing an association to cancel a contract if certain conflicts were not disclosed, specifying liability and non-liability of the association upon cancellation of a contract, defining the term relative, reenacting and amending S. 468.436 FS, revising the list of grounds for which the Department of Business and Professional Regulation may take disciplinary actions against community association managers or community association firms, amending S. 553.899 FS, exempting certain four-family dwellings from requiring a milestone inspection and milestone inspection report, amending S. 718.103 FS, revising and providing definitions, amending S. 718.104 FS, providing requirements for the declaration of specified condominiums, requiring declarations to specify the entity responsible for the installation, maintenance, repair, or replacement of hurricane protection, amending S. 718.111 FS, providing criminal penalties for any officer, director, or manager of an association who unlawfully solicits, offers to accept, or accepts a kickback, requiring such officers, directors, or managers to be removed from office and a vacancy declared, requiring the Division of Florida Condominiums, Timeshares, and Mobile Homes to monitor an association's compliance with certain provisions and issue fines and penalties if necessary upon receipt of a complaint, revising the list of records that constitute the official records of an association, providing requirements relating to email addresses and facsimile numbers of unit owners, requiring an association to redact certain personal information in certain documents, providing an Exception to liability for the release of certain information. Revising. Maintenance requirements for official records. Revising requirements. Regarding requests to inspect or copy association records, requiring an association to provide a checklist in response to certain records requests. Providing a rebuttable presumption and criminal penalties, requiring certain persons to be removed from office and a vacancy declared under certain circumstances, defining the term repeatedly, requiring copies of certain building permits be posted on an association's website or application, modifying the method of delivery of certain financial reports. To unit owners, revising circumstances under which an association may prepare certain reports, revising criminal penalties for persons who unlawfully use a debit card issued in the name of an association, requiring certain persons to be removed from office and a vacancy declared under certain circumstances, defining the term lawful obligation of the association, revising the threshold for associations that must post certain documents on its website or through an application, amending S. 718.112 FS, requiring the boards of certain associations to meet at least once every quarter, requiring the meeting agenda to include an opportunity for members to ask questions of the board a certain number of times a year, providing that the right to attend meetings includes the right to ask questions relating to certain topics, revising requirements regarding notice of such meetings, requiring a director to complete an educational requirement within a specified time period before or after election or appointment to the board, providing requirements for the educational curriculum, providing transitional provisions, requiring a director to complete a certain amount of continuing education each year relating to changes in the law, requiring the secretary of the association to maintain certain information for inspection for a specified number of years, authorizing members of an association to pause the contribution to reserves or reduce reserves under certain circumstances and for a limited time, authorizing the board to expend reserve account funds to make the condominium building and structures habitable, requiring an association to distribute or deliver copies of a structural integrity reserve study to unit owners within a specified time frame, specifying the manner of distribution or delivery, requiring an association to provide a specified statement to the division within a specified time frame, revising the circumstances under which a director or an officer must be removed from office after being charged by information or indictment of certain crimes, prohibiting such officers and directors with pending criminal charges from accessing the official records of any association, providing an exception, providing criminal penalties for certain fraudulent voting activities relating to association elections, amending S. 718.113 FS, providing applicability, specifying that certain actions are not material alterations or substantial additions, authorizing the boards of residential and mixed-use condominiums to install or require unit owners to install hurricane protection, requiring a vote of the unit owners for the installation of hurricane protection, requiring that such vote be attested to in a certificate and recorded in certain public records, requiring the board to provide, in various manners, to the unit owners a copy of the recorded certificate, providing that the validity or enforceability of a vote is not affected if the board fails to take certain actions, providing that a vote of the unit owners is not required under certain circumstances, prohibiting installation of the same type of hurricane protection previously installed, providing exceptions, prohibiting the boards of residential and mixed-use condominiums from refusing to approve certain hurricane protections, authorizing the board to require owners to adhere to certain guidelines regarding the external appearance of a condominium, revising responsibility for the cost of the removal or reinstallation of hurricane protection, including exterior windows, doors, or apertures, prohibiting the association from charging certain expenses to unit owners, requiring reimbursement or a credit toward future assessments to the unit owner in certain circumstances, authorizing the association to collect certain charges and specifying that such charges are enforceable as assessments under certain circumstances, Amending S. 718.115 FS, specifying when the cost of installation of hurricane protection is not a common expense, authorizing certain expenses to be enforceable as assessments, requiring certain unit owners to be excused from certain assessments or to receive a credit for hurricane protection that has been installed, providing credit applicability under certain circumstances, providing for the amount of credit that a unit owner must receive, specifying that certain expenses are common expenses, amending S. 718.121 FS, conforming a cross-reference, amending S. 718.124 FS, providing the statute of limitations and repose for certain actions, amending S. 718.1224 FS, revising legislative findings and intent, revising the definition of the term governmental entity, prohibiting an association from filing strategic lawsuits, taking certain actions against unit owners, and expending funds to support certain actions, amending S. 718.128 FS, providing that a unit owner may consent to electronic voting electronically, providing that a board must honor a unit owner's request to vote electronically until the owner opts out, amending S. 718.202 FS, providing sales and reservation deposit requirements for non-residential condominiums, amending S. 718.301 FS, requiring developers to deliver a structural integrity reserve report to an association upon relinquishing control of the association, amending S. 718.3027 FS, revising requirements regarding attendance at a board meeting in the event of a conflict of interest, modifying circumstances under which a contract may be voided, revising a cross-reference, amending S. 718.303 FS, requiring an association to provide certain notice to a unit owner by a specified time before an election, creating S. 718.407 FS, authorizing a condominium to be created within a portion of a building or within a multiple parcel building, specifying that the common elements are only those portions of the building submitted to the condominium form of ownership, providing requirements for the declaration of such condominiums and other certain recorded instruments, providing for the apportionment of expenses for such condominiums, authorizing the association to inspect and copy certain books and records, requiring a specified disclosure summary for contracts of sale for a unit in certain condominiums, providing that the creation of a multiple parcel building is not a subdivision of the land, amending S. 718.501 FS, revising circumstances under which the division has jurisdiction to investigate and enforce complaints relating to certain matters, requiring that the division provide official records without charge to a unit owner denied access, authorizing the division to issue certain citations, requiring the division to provide a division-approved training provider with the template for the certificate issued to certain directors of a board of administration, requiring that the division refer suspected criminal acts to the appropriate law enforcement authority, authorizing the division to request access to an association's website or providing applicability, amending S. 718.5011 FS, providing that the Secretary of the Department of Business and Professional Regulation, amending S. 718.503 FS, requiring non-developer unit owners to include an annual financial statement and annual budget and information provided to a prospective purchaser, revising information that must be included in contracts for the resale of a residential unit, requiring certain disclosures be made if a unit is located in a specified type of condominium, amending S. 718.504 FS, requiring certain information provided to prospective Purchasers to state whether the condominium is created within a portion of a building or within a multiple parcel building. Amending S. 719.106. FS. Requiring an association to distribute or deliver copies of a structural integrity reserve study to unit owners within a specified timeframe. Specifying the manner of distribution or delivery. Requiring an association to provide a specified statement to the division within a specified timeframe. Amending S. 719.129 FS. Providing that a unit owner may consent electronically to electronic voting. Amending S. 719.301 FS. Requiring developers to deliver a structural integrity reserve study to a cooperative association upon relinquishing control of association property. Requiring the division to conduct a review of statutory requirements regarding posting of official records on a condominium association's website or application, requiring the division to submit its findings, including any recommendation, to the governor and the legislature by a specified date, requiring the division to create a database on its website with certain information by a date certain, providing appropriations, providing construction and retroactive application, requiring the Florida Building Commission to perform a study for specified purposes, requiring the Commission to submit a report of its recommendations to the governor and legislature by a date certain, providing effective dates. Be it enacted by the legislature of the state of Florida. Section 1. Subsection 3 is added to Section 468.4334, Florida statutes, to read 468.4334 Professional Practice Standards. Liability. 3. A community association manager or a community association management firm shall return all community association official records within its possession to the community association within 20 business days after termination of a contractual agreement to provide community association management services to the community association or receipt of a written request for return of the official records, whichever occurs first. A notice of termination of a contractual agreement to provide community association management services must be sent by certified mail, return, receipt requested, or in the manner required under such contractual agreement. The community association manager or community association management firm may retain, for up to 20 business days, those records necessary to complete an ending financial statement or report, if an association fails to provide access to or retention of the accounting records. To prepare an ending financial statement or report, the community association manager or community association management firm is relieved from any further responsibility or liability relating to the preparation of such ending financial statement or report. Failure of a community association manager or a community association management firm to timely return all of the official records within its possession to the community association creates a rebuttable presumption that the community association manager or community association management firm willfully failed to comply with this subsection. A community association manager or a community association management firm that fails to timely return community association records is subject to suspension of its license under S. 468.436 and a civil penalty of $1,000 per day for up to 10 business days, assessed beginning on the 21st business day after termination of a contractual agreement to provide community association management services to the community association or receipt of a written request from the association for return of the record, whichever occurs first. However, for a timeshare plan created under Chapter 721, the time periods provided in S. 721.144b apply. Section 2. Section 468.4335, Florida statutes, is created to read 468.4335 Conflicts of interest. 1. A community association manager or a community association management firm, including directors, officers, and persons with a financial interest in a community association management firm or a relative of such persons, must disclose to the board of a community association any activity that may reasonably be construed to be a conflict of interest. A rebuttable presumption of a conflict of interest exists if any of the following occurs. Without prior notice, a community association manager or a community association management firm, including directors, officers, and persons with a financial interest in a community association management firm or a relative of such persons, enters into a contract for goods or services with the association. Be a community association manager or a community association management firm, including directors, officers, and persons with a financial interest in a community association management firm or a relative of such persons, holds an interest in or receives compensation or anything of value from a corporation, limited liability corporation, partnership, limited liability partnership, or other business entity that conducts business with the association or proposes to enter into a contract or other transaction with the association. 2. If the association receives and considers a bid that exceeds $2,500 to provide a good or service other than community association management services from a community association manager or a community association management firm, including directors, officers, and persons with a financial interest in a community association management firm or a relative of such persons, the association must solicit multiple bids from other third-party providers of such goods or services. 3. If a community association manager or a community association management firm, including directors, officers, and persons with a financial interest in a community association management firm or a relative of such persons, proposes to engage in an activity that is a conflict of interest as described in subsection 1, the proposed activity must be listed on and all contracts and transactional documents related to the proposed activity must be attached to the meeting agenda of the next Board of Administration meeting. The disclosures of a possible conflict of interest must be entered into the written minutes of the meeting. Approval of the contract, including a management contract between the community association and the community association manager or community association management firm, or other transaction, requires an affirmative vote of 2/3 of all directors present at the next regular or special meeting of the members. The existence of the conflict of interest and the contract or other transaction must be disclosed to the members. If a community association manager or community association management firm has previously disclosed a conflict of interest in an existing management contract entered into between the board of directors and the community association manager or community association management firm, the conflict of interest does not need to be additionally noticed and voted on during the term of such management contract, but, upon renewal, must be noticed and voted on in accordance with this subsection. 4. If the board finds that a community association manager or a community association management firm, including directors, officers, and persons with a financial interest in a community association management firm, or a relative of such persons, has violated this section, the association may cancel its community association management contract with the community association manager or the community association management firm. If the contract is canceled, the association is liable only for the reasonable value of the management services provided up to the time of cancellation and is not liable for any termination fees, liquidated damages, or other form of penalty for such cancellation. 5. If an association enters into a contract with a community association manager or a community association management firm, including directors, officers, and persons with a financial interest in a community association management firm, or a relative of such persons, which is a party to or has an interest in an activity that is a possible conflict of interest as described in subsection 1, and such activity has not been properly disclosed as a conflict of interest or potential conflict of interest as required by this section, the contract is voidable and terminates upon the association filing a written notice terminating the contract with its board of directors, which contains the consent of at least 20% of the voting interests of the association. 6 is used in this section. The term relative means a relative within the third degree of consanguinity by blood or marriage, must redact such personal information before the document is disseminated. C3. E. However, the association is not liable for an inadvertent disclosure of the email address or facsimile number for receiving electronic transmission of notices unless such disclosure was made with a knowing or intentional disregard of the protected nature of such information. 8. All current insurance policies of the association and condominiums operated by the association. 9. A current copy of any management agreement, lease, or other contract to which the association is a party or under which the association or the unit owners have an obligation or responsibility. 10. Bills of sale or transfer for all property owned by the association. 11. Accounting records for the association and separate accounting records for each condominium that the association operates. Any person who knowingly or intentionally defaces or destroys such records, or who knowingly or intentionally fails to create or maintain such records with the intent of causing harm to the association or one or more of its members, is personally subject to a civil penalty pursuant to S. 718.5011 ES. 718.5011D. The accounting records must include, but are not limited to: A. Accurate, itemized, and detailed records of all receipts and expenditures. B. All invoices, transaction receipts, or deposit slips that substantiate any receipt or expenditure of funds by the association. CB. A current account and a monthly, bimonthly, or quarterly statement of the account for each unit designating the name of the unit owner, the due date and amount of each assessment, the amount paid on the account, and the balance due. DC. All audits, reviews, accounting statements, structural integrity, reserve studies, and financial reports of the association or condominium. Structural integrity reserve studies must be maintained for at least 15 years after the study is completed. ED. All contracts for work to be performed, bids for work to be performed, are also considered official records and must be maintained by the association for at least 1 year after receipt of the bid. 12. Ballots, sign-in sheets, voting proxies, and all other papers and electronic records relating to voting by unit owners, which must be maintained for 1 year from the date of the election, vote, or meeting to which the document relates, notwithstanding paragraph B. 13. All rental records if the association is acting as agent for the rental of condominium units. 14. A copy of the current question and answer sheet as described in S. 718.504. 15. A copy of the inspection reports described in SS 553.899 and 718.3014P and any other inspection report relating to a structural or life safety inspection of condominium property. Such record must be maintained by the association for 15 years after receipt of the report. 16. Bids for materials, equipment, or services. 17. All affirmative acknowledgments made pursuant to S. 718.1214C. 18. A copy of all building permits. 19. A copy of all satisfactorily completed board member educational certificates. 20. All other written records of the association not specifically included in the foregoing which are related to the operation of the association. B. The official records specified in subparagraphs 1-6 must be permanently maintained from the inception of the association. Bids for work to be performed or for materials, equipment, or services must be maintained for at least 1 year after receipt of the bid. All other official records must be maintained within the state for at least 7 years, unless otherwise provided by general law. The official records must be maintained in an organized manner that facilitates inspection of the records by a unit owner in the event that the official records are lost, destroyed, or otherwise unavailable. The obligation to maintain the official records includes a good faith obligation to obtain and recover those records as is reasonably possible. The records of the association shall be made available to a unit owner within 45 miles of the condominium property or within the county in which the condominium property is located within 10 working days after receipt of a written request by the board or its designee. However, such distance requirement does not apply to an association governing a timeshare condominium. This paragraph and paragraph C may be complied with by having a copy of the official records of the association available for inspection or copying on the condominium property or association property, or the association may offer the option of making the records available to a unit owner electronically via the internet as provided under paragraph G, or by allowing the records to be viewed in electronic format on a computer screen and printed upon request. The association is not responsible for the use or misuse of the information provided to an association member or his or her authorized representative in compliance with this chapter unless the association has an affirmative duty not to disclose such information under this chapter. C1. A. The official records of the association are open to inspection by any association member and any person authorized by an association member as a representative of such member at all reasonable times. The right to inspect the records includes the right to make or obtain copies at the reasonable expense, if any, of the member and of the person authorized by the association member as a representative of such member. A renter of a unit has a right to inspect and copy only the declaration of condominium, the association's bylaws and rules, and the inspection reports described in SS 553.899 and 718.3014p. The association may adopt reasonable rules regarding the frequency, time, location, notice, and manner of record inspections and copying, but may not require a member to demonstrate any purpose or state any reason for the inspection. The failure of an association to provide the records within 10 working days after receipt of a written request creates a rebuttable presumption that the association willfully failed to comply with this paragraph. A unit owner who is denied access to official records is entitled to the actual damages or minimum damages for the association's willful failure to comply. Minimum damages are $50 per calendar day for up to 10 days, beginning on the 11th working day after receipt of the written request. The failure to permit inspection entitles any person prevailing in an enforcement action to recover reasonable attorney fees from the person in control of the records who directly or indirectly knowingly denied access to the records. If the requested records are posted on an association's website or are available for download through an application on a mobile device, the association may fulfill its obligations. Section 3. Paragraph B of subsection 2 of Section 468.436, Florida statutes is amended, and subsection 4 of that section is reenacted to read 468.436 Disciplinary Proceedings. 2. The following acts constitute grounds for which the disciplinary actions in subsection 4 may be taken. B1. Violation of any provision of this part. 2. Violation of any lawful order or rule rendered or adopted by this department or the council. 3. Being convicted of or pleading nolo contendere to a felony in any court in the United States. 4. Obtaining a license or certification or any other order, ruling, or authorization by means of fraud, misrepresentation, or concealment of material facts. 5. Committing acts of gross misconduct or gross negligence in connection with the profession. 6. Contracting on behalf of an association with any entity in which the licensee has a financial interest that is not disclosed. 7. Failing to disclose any conflict of interest as required by S. 468.4335. 8.7. Violating Chapter 718, Chapter 719, or Chapter 720. During the course of performing community association management services pursuant to a contract with a community association as defined in S. 468.4311. 4. When the department finds any community association manager or firm guilty of any of the grounds set forth in subsection 2, it may enter an order imposing one or more of the following penalties: a denial of an application for licensure, B. revocation or suspension of a license, C. imposition of an administrative fine not to exceed $5,000 for each count or separate offense, D. issuance of a reprimand, E. placement of the community association manager on probation for a period of time and subject to such conditions as the department specifies, F. restriction of the authorized scope of practice by the community association manager. Section 4. Subsection 4 of Section 553.899 Florida statutes is amended to read 553.899 mandatory structural inspections for condominium and cooperative buildings. 4. The milestone inspection report must be arranged by a condominium or cooperative association and any owner of any portion of the building which is not subject to the condominium or cooperative form of ownership. The condominium association or cooperative association and any owner of any portion of the building which is not subject to the condominium or cooperative form of ownership are each responsible for ensuring compliance with the requirements of this section. The condominium association or cooperative association is responsible for all costs associated with the milestone inspection attributable to the portions of a building which the association is responsible to maintain under the governing documents of the association. This section does not apply to a single-family, two-family, or three-family or four-family dwelling with 3 or fewer habitable stories above ground. Section 5. Subsections 19 through 32 of Section 718.103, Florida statute, are renumbered as subsections 21 through 34, respectively. Subsection 14 is amended, and new subsections 19 and 20 are added to that section to read 718.103 definitions. As used in this chapter, the term 14 condominium property means the lands, leaseholds, and improvements, any personal property, and all easements and rights appurtenant thereto, regardless of whether contiguous, which are subjected to condominium ownership. 19 hurricane protection means hurricane shutters, impact glass, code-compliant windows or doors, and other code-compliant hurricane protection products used to preserve and protect the condominium property or association property. 20 kickback means anything or service of value for which consideration has not been provided for an officer's, a director's, or a manager's own benefit or that of his or her immediate family from any person providing or proposing to provide goods or services to the association. Section 6. Paragraph B of subsection 4 of Section 718.104, Florida statutes, is amended, and paragraph P is added to that subsection to read 718.104 Creation of condominiums. Contents of declaration. Every condominium created in this state shall be created pursuant to this chapter. 4. The declaration must contain or provide for the following matters. B. The name by which the condominium property is to be identified, which shall include the word condominium or be followed by the words a condominium. Condominiums created within a portion of a building or within a multiple parcel building must include the name by which the condominium is to be identified and be followed by a condominium within a portion of a building or within a multiple parcel building. P for both residential condominiums and mixed-use condominiums. A statement that specifies whether the unit owner or the association is responsible for the installation, maintenance, repair, or replacement of hurricane protection, that is, for the preservation and protection of the condominium property and association property. Section 7. Paragraph A of subsection 1, paragraph H of subsection 11, and subsections 12, 13, and 15 of Section 718.111, Florida statutes, are amended to read 718.111 The association. 1. Corporate entity of the operation of the condominium shall be by the association, which must be a Florida corporation for profit or a Florida corporation not for profit. However, any association which was in existence on January 1st, 1977, need not be incorporated The owners of units shall be shareholders or members of the association. The officers and directors of the association have a fiduciary relationship to the unit owners. It is the intent of the legislature that nothing in this paragraph shall be construed as providing for or removing a requirement of a fiduciary relationship between any manager employed by the association and the unit owners. An officer, a director, or a manager may not solicit, offer to accept, or accept a kickback. Any such officer, director, or manager who knowingly so solicits, offers to accept, or accepts a kickback commits a felony of the third degree, punishable as provided in S. 775.082, S. 775.083, or S. 775.084, is subject to a civil penalty pursuant to S. 718.5011E and must be removed from office and a vacancy declared. However, this paragraph does not prohibit an officer, a director, or a manager from accepting services or items received in connection with trade fairs or education programs. An association may operate more than one condominium. 11. Insurance. In order to protect the safety, health, and welfare of the people of the state of Florida and to ensure consistency in the provision of insurance coverage to condominiums and their unit owners, this subsection applies to every residential condominium in the state, regardless of the date of its declaration of condominium. It is the intent of the legislature to encourage lower or stable insurance premiums for associations described in this subsection. H. The association shall maintain insurance or fidelity bonding of all persons who control or disperse funds of the association. The insurance policy or fidelity bond must cover the maximum funds that will be in the custody of the association or its management agent at any one time. Upon receipt of a complaint, the division shall monitor an association for compliance with this paragraph and may issue fines and penalties established by the division for failure of an association to maintain the required insurance policy or fidelity bond. As used in this paragraph, the term persons who control or disperse funds of the association includes, but is not limited to, those individuals authorized to sign checks on behalf of the association and the president, secretary, and treasurer of the association. The association shall bear the cost of any such bonding. 12. Official records. From the inception of the association shall maintain each of the following items, if applicable, which constitutes the official records of the association. 1. A copy of the plans, permits, warranties, and other items provided by the developer under S. 718.3014. 2. A photocopy of the recorded declaration of condominium of each condominium operated by the association and each amendment to each declaration. 3. A photocopy of the recorded bylaws of the association and each amendment to the bylaws. 4. A certified copy of the articles of incorporation of the association or other documents creating the association and each amendment thereto. 5. A copy of the current rules of the association. 6. A book or books that contain the minutes of all meetings of the association, the board of administration, and the unit owners. 7. A current roster of all unit owners and their mailing addresses, unit identifications, voting certifications, and, if no, telephone numbers. The association shall also maintain the email addresses and facsimile numbers of unit owners consenting to receive notice by electronic transmission, in accordance with subparagraph C5. E. The email addresses and facsimile numbers are only accessible to unit owners if consent to receive notice by electronic transmission is provided, or if the unit owner has expressly indicated that such personal information can be shared with other unit owners and the unit owner has not provided the association with a request to opt out of such dissemination with other unit owners. An association must ensure that the email addresses and facsimile numbers are only used for the business operation of the association and may not be sold or shared with outside third parties. if such personal information is included in documents that are released to third parties other than unit owners, the association. C3. E. However, the association is not liable for an inadvertent disclosure of the email address or facsimile number for receiving electronic transmission of notices unless such disclosure was made with a knowing or intentional disregard of the protected nature of such information. 8. All current insurance policies of the association and condominiums operated by the association. 9. A current copy of any management agreement, lease, or other contract to which the association is a party or under which the association or the unit owners have an obligation or responsibility. 10. Bills of sale or transfer for all property owned by the association. 11. Accounting records for the association and separate accounting records for each condominium that the association operates. Any person who knowingly or intentionally defaces or destroys such records, or who persons authorized to request access. B. In response to a written request to inspect records, the association must simultaneously provide to the requester a checklist of all records made available for inspection and copying. The checklist must also identify any of the association's official records that were not made available to the requester. An association must maintain a checklist provided under this subparagraph for 7 years. An association delivering a checklist pursuant to this subparagraph creates a rebuttable presumption that the association has complied with this paragraph. 2. A director or member of the board or association or a community association manager who knowingly, willfully, and repeatedly violates subparagraph 1 commits a misdemeanor of the second degree, punishable, as provided in S. 775.082 or S. 775.083, and must be removed from office and a vacancy declared. For purposes of this subparagraph, the term repeatedly means 2 or more violations within a 12-month period. 3. Any person who knowingly or intentionally defaces or destroys accounting records that are required by this chapter to be maintained during the period for which such records are required to be maintained, or who knowingly or intentionally fails to create or maintain accounting records that are required to be created or maintained with the intent of causing harm to the association or one or more of its members, commits a misdemeanor of the first degree, punishable as provided in S. 775.082 or S. 775.083, is personally subject to a civil penalty pursuant to S. 718.5011d, and must be removed from office and a vacancy declared. 4. A person who willfully and knowingly refuses to release or otherwise produce association records with the intent to avoid or escape detection, arrest, trial, or punishment for the commission of a crime, or to assist another person with such avoidance or escape, commits a felony of the third degree, punishable as provided in S. 775.082, S. 775.083, or S. 775.084, and must be removed from office and a vacancy declared. 5. The association shall maintain an adequate number of copies of the Declaration, Articles of Incorporation, bylaws, and rules, and all amendments to each of the foregoing, as well as the question and answer sheet as described in S. 718.504 and year-end financial information required under this section on the condominium property to ensure their availability to unit owners and prospective purchasers, and may charge its actual costs for preparing and furnishing these documents to those requesting the documents. An association shall allow a member or his or her authorized representative to use a portable device, including a smartphone, tablet, portable scanner, or any other technology capable of scanning or taking photographs to make an electronic copy of the official records in lieu of the associations providing the member or his or her authorized representative with a copy of such records. The association may not charge a member or his or her authorized representative for the use of a portable device. Notwithstanding this paragraph, the following records are not accessible to unit owners. A. Any record protected by the lawyer-client privilege as described in S. 90.502 and any record protected by the work product privilege, including a record prepared by an association attorney or prepared at the attorney's express direction, which reflects a mental impression, conclusion, litigation, strategy, or legal theory of the attorney or the association, and which was prepared exclusively for civil or criminal litigation or for adversarial, administrative proceedings, or which was prepared in anticipation of such litigation or proceedings until the conclusion of the litigation or proceedings. B. Information obtained by an association in connection with the approval of the lease, sale, or other transfer of a unit. C. Personnel records of association or management company employees, including, but not limited to, disciplinary, payroll, health, and insurance records. For purposes of this subparagraph, the term personnel records does not include written employment agreements with an association employee or management company, or budgetary or financial records that indicate the compensation paid to an association employee. D. Medical records of unit owners. E. Social security numbers, driver license numbers, credit card numbers, email addresses, telephone numbers, facsimile numbers, emergency contact information, addresses of a unit owner other than as provided to fulfill the association's notice requirements, and other personal identifying information of any person, excluding the person's name, unit designation, mailing address, property address, and any address, email address, or facsimile number provided to the association to fulfill the association's notice requirements, notwithstanding the restrictions in this subparagraph. An association may print and distribute to unit owners a directory containing the name, unit address, and all telephone numbers of each unit owner. However, an owner may exclude his or her telephone numbers from the directory by so requesting in writing to the association. An owner may consent in writing to the disclosure of other contact information described in this subparagraph. The association is not liable for the inadvertent disclosure of information that is protected under this subparagraph if the information is included in an official record of the association and is voluntarily provided by an owner and not requested by the association. F. Electronic security measures that are used by the association to safeguard data, including passwords. G. The software and operating system used by the association which allow the manipulation of data, even if the owner owns a copy of the same software used by the association. The data is part of the official records of the association. H. All affirmative acknowledgments made pursuant to S. 718.1214c. D. The association shall prepare a question and answer sheet as described in S. 718.504 and shall update it annually. E1. The association or its authorized agent is not required to provide a prospective purchaser or lien holder with information about the condominium or the association other than information or documents required by this chapter to be made available or disclosed. The association or its authorized agent may charge a reasonable fee to the prospective purchaser, lien holder, or the current unit owner for providing good faith responses to requests for information by or on behalf of a prospective purchaser or lien holder, other than that required by law, if the fee does not exceed $150 plus the reasonable cost of photocopying and any attorney's fees incurred by the association in connection with the response. 2. An association and its authorized agent are not liable for providing such information in good faith pursuant to a written request if the person providing the information includes a written statement in substantially the following form. The responses herein are made in good faith and to the best of my ability as to their accuracy. F. An outgoing board or committee member must relinquish all official records and property of the association in his or her possession or under his or her control to the incoming board within 5 days after the election. The Division shall impose a civil penalty as set forth in S. 718.5011D6 against an outgoing board or committee member who willfully and knowingly fails to relinquish such records and property. G1. By January 1st, 2019, an association managing a condominium with 150 or more units which does not contain timeshare units shall post digital copies of the documents specified in subparagraph 2 on its website or make such documents available through an application that can be downloaded on a mobile device. A. The association's website or application must be an independent website, application, or web portal wholly owned and operated by the association, or Roman II, a website, application, or web portal operated by a third party provider with whom the association owns, leases, rents, or otherwise obtains the right to operate a web page, subpage, web portal, collection of subpages, or web portals, or an application which is dedicated to the association's activities and on which required notices, records, and documents may be posted or made available by the association. B. The association's website or application must be accessible through the Internet and must contain a subpage, web portal, or other protected electronic location that is inaccessible to the general public and accessible only to unit owners and employees of the association. C. Upon a unit owner's written request, the association must provide the unit owner with a username and password and access to the protected sections of the association's website or application which contain any notices, records, or documents that must be electronically provided. 2. A current copy of the following documents must be posted in digital format on the association's website or application. A. The recorded declaration of condominium of each condominium operated by the association and each amendment to each declaration. B. The recorded bylaws of the association and each amendment to the bylaws. C. The articles of incorporation of the association or other documents creating the association and each amendment to the articles of incorporation or other documents. The copy posted pursuant to this subparagraph must be a copy of the articles of incorporation filed with the Department of State. D. The rules of the association. E. A list of all executory contracts or documents to which the association is a party or under which the association or the unit owners have an obligation or responsibility and, after bidding for the related materials, equipment, or services has closed, a list of bids received by the association within the past year. Summaries of bids for materials, equipment, or services which exceed $500 must be maintained on the website or application for 1 year. In lieu of summaries, complete copies of the bids may be posted. F. The annual budget required by S. 718.1122F and any proposed budget to be considered at the annual meeting. G. The financial report required by subsection 13 and any monthly income or expense statement to be considered at a meeting. H. The certification of each director required by S. 718.1122D4. B. I. All contracts or transactions between the association and any director, officer, corporation, firm, or association that is not an affiliated condominium association or any other entity in which an association director is also a director or officer and financially interested. J. Any contract or document regarding a conflict of interest or possible conflict of interest as provided in SS 468.4335, 468.4362B6, and 718.30273. K. The notice of any unit owner meeting and the agenda for the meeting, as required by S. 718.1122D3, no later than 14 days before the meeting. The notice must be posted in plain view on the front page of the website or application, or on a separate subpage of the website or application labeled Notices, which is conspicuously visible and linked from the front page. The Association must also post on its website or application any document to be considered and voted on by the owners during the meeting or any document listed on the agenda at least 7 days before the meeting at which the document or the information within the document will be considered. L. Notice of any board meeting, the agenda, and any other document required for the meeting as required by S. 718.1122C, which must be posted no later than the date required for notice under S. 718.1122C. M. The inspection reports described in SS 553.899 and 718.3014P and any other inspection report relating to a structural or life safety inspection of condominium property. N. The association's most recent structural integrity reserve study, if applicable. O. Copies of all building permits issued for ongoing or planned construction. 3. The association shall ensure that the information and records described in paragraph C, which are not allowed to be accessible to unit owners, are not posted on the association's website or application. If protected information or information restricted from being accessible to unit owners is included in documents that are required to be posted on the association's website or application, the association shall ensure the information is redacted before posting the documents. Notwithstanding the foregoing, the association or its agent is not liable for disclosing information that is protected or restricted under this paragraph unless such disclosure was made with a knowing or intentional disregard of the protected or restricted nature of such information. 4. The failure of the association to post information required under subparagraph 2 is not in and of itself sufficient to invalidate any action or decision of the association's board or its committees. 13. Financial reporting. Within 90 days after the end of the fiscal year or annually on a date provided in the bylaws, the association shall prepare and complete or contract for the preparation and completion of a financial report for the preceding fiscal year within 21 days after the final financial report is completed by the association or received from the third party, but not later than 120 days after the end of the fiscal year or other date as provided in the bylaws. The association shall deliver mail to each unit owner by United States mail or personal delivery at the mailing address, property address, email address, or facsimile number provided to fulfill the association's notice requirements, a copy of the most recent financial report, and or a notice that a copy of the most recent financial report will be mailed or hand-delivered to the unit owner without charge within 5 business days after receipt of a written request from the unit owner. The division shall adopt rules setting forth uniform accounting principles and standards to be used by all associations and addressing the financial reporting requirements for multi-condominium associations. The rules must include, but not be limited to, standards for presenting a summary of association reserves, including a good faith estimate disclosing the annual amount of reserve funds that would be necessary for the association to fully fund reserves for each reserve item, based on the straight-line accounting method. This disclosure is not applicable to reserves funded via the pooling method. In adopting such rules, the division shall consider the number of members and annual revenues of an association. Financial reports shall be prepared as follows. An association that meets the criteria of this paragraph shall prepare a complete set of financial statements in accordance with generally accepted accounting principles. The financial statements must be based upon the association's total annual revenues as follows. 1. An association with total annual revenues of $150,000 or more, but less than $300,000, shall prepare compiled financial statements. 2. An association with total annual revenues of at least $300,000, but less than $500,000, shall prepare reviewed financial statements. 3. An association with total annual revenues of $500,000 or more shall prepare audited financial statements. B1. An association with total annual revenues of less than $150,000 shall prepare a report of cash receipts and expenditures. 2. A report of cash receipts and disbursements must disclose the amount of receipts by accounts and receipt classifications and the amount of expenses by accounts and expense classifications, including, but not limited to, the following, as applicable: costs for security, professional and management fees and expenses, taxes, costs for recreation facilities, expenses for refuse collection and utility services, expenses for lawn care, costs for building maintenance and repair, insurance costs, administration and salary expenses, and reserves accumulated and expended for capital expenditures, deferred maintenance, and any other category for which the association maintains reserves. C. An association may prepare, without a meeting of or approval by the unit owners: 1. Compiled, reviewed, or audited financial statements if the association is required to prepare a report of cash receipts and expenditures. 2. Reviewed or audited financial statements if the association is required to prepare compiled financial statements. Or 3. Audited financial statements if the association is required to prepare reviewed financial statements. D. If approved by a majority of the voting interest present at a properly called meeting of the association, an association may prepare: 1. A report of cash receipts and expenditures in lieu of a compiled, reviewed, or audited financial statement. 2. A report of cash receipts and expenditures or a compiled financial statement in lieu of a reviewed or audited financial statement. Or 3. A report of cash receipts and expenditures, a compiled financial statement, or a reviewed financial statement in lieu of an audited financial statement. Such meeting and approval must occur before the end of the fiscal year and is effective only for the fiscal year in which the vote is taken. An association may not prepare a financial report pursuant to this paragraph for consecutive fiscal years if the developer has not turned over control of the association. All unit owners, including the developer, may vote on issues related to the preparation of the association's financial reports from the date of incorporation of the association through the end of the second fiscal year after the fiscal year in which the certificate of a surveyor and mapper is recorded pursuant to S. 718.1044E, or an instrument that transfers title to a unit in the condominium which is not accompanied by a recorded assignment of developer rights in favor of the grantee of such unit is recorded, whichever occurs first. Thereafter, all unit owners except the developer may vote on such issues until control is turned over to the association by the developer. Any audit or review prepared under this section shall be paid for by the developer if done before turnover of control of the association. E. A unit owner may provide written notice to the division of the association's failure to mail or hand deliver him or her a copy of the most recent financial report within 5 business days after he or she submitted a written request to the association for a copy of such report. If the division determines that the association failed to mail or hand deliver a copy of the most recent financial report to the unit owner, the division shall provide written notice to the association that the association must mail or hand deliver a copy of the most recent financial report to the unit owner and the division within 5 business days after it receives such notice from the division. An association that fails to comply with the division's request may not waive the financial reporting requirement provided in paragraph D4. The fiscal year in which the unit owner's request was made and the following fiscal year. A financial report received by the division pursuant to this paragraph shall be maintained, and the division shall provide a copy of such report to an association member upon his or her request. 15. Debit cards. An association and its officers, directors, employees, and agents may not use a debit card issued in the name of the association or billed directly to the association for the payment of any association expense. B. A person who uses a debit card issued in the name of the association or billed directly to the association for any expense that is not Lawful obligation of the association commits theft under S. 812.014 and must be removed from office and a vacancy declared. For the purposes of this paragraph, the term lawful obligation of the association means an obligation that has been properly pre-approved by the board and is reflected in the meeting minutes or the written budget.